So when is a good time to start your labor certification if you are an H-1B worker, or if you work for an organization, then you're in charge of deciding when the company starts the H-1B or starts the labor certification for an H-1B worker. Um, it used to be a lot faster, so it used to be pretty normal for companies to make their H-1B worker wait until they're maybe even in their 5th year of H-1B status. Then for a while, the economy was pretty hot and labor certifications were slowing down, prevailing wages were slowing down, and it became a more common thing that actually got hashed out in the offer and negotiation process. So a lot of employees had it set that their employer would start their labor certification right away. In my practice now, I really encourage my corporate clients to start the labor certification when they've got at least 3 years left in H-1B status for their worker. So if we get to the first H-1, if it's someone who came from their first H-1B was with that company, um, then when they do their first renewal, that's a great time to start the labor certification. Um, if the H-1B worker has only ever worked for that company that's doing the labor certification, it can make the labor certification very tricky, because the employment experience that the H-1B worker or other foreign worker is trying to leverage to show that they're qualified for the green card job being offered to them isn't supposed to be from the employer that is sponsoring the green card. And the reasoning behind that is because if the employer was willing to train a foreign worker to do the job that's the green card job, then the employer should be willing to train a US worker. So the sponsored worker for labor certification needs to count all of their experience that they got before they came to that company at all. Or if they're counting experience with that company, they need to show that it was in a job that was substantially different than what the green card job will be. So let's say they came straight out of school, they were an international student, they had OPT, and they were an intern. And they were promoted to junior analyst. And then they were promoted to regular analyst. And then they were promoted to senior analyst. And the green card job is going to be director of analysis. Each one of those jobs has a job description with duties, and the way that the company would show that the foreign worker is qualified is by saying, hey, the internship, the junior analyst, the analyst, and the senior analyst roles are all different from the director of analysis. Let's do this analysis where we say, okay, we've got these 10 job duties. Here's how they divided the time. They did 5% of their time on this, 10% of their time on this. Each thing, show how, they used to do this duty and then they did it a smaller percentage of their time. And then by the next promotion, they weren't doing it at all. And then these other duties came online, and look, mathematically, they're spending their time very differently. They're not spending their time on the same, it's essentially not the same job. It's more, most of their time is spent differently with the experience they're leveraging from how they're going to do in their green card job. Now, I work with a lot of employers who really wring their hands about what is my employee going to be doing by the time they get their green card, and is this labor certification based on the right job? That's so tricky because you don't know exactly what you're going to get the green card. So how can you really know what your employee is going to be doing in the future when you don't know when exactly that future is going to be? And even if you do, but it's going to be some long time, like, okay, it's going to be, in 2031, what's his job going to be? How would you know? The company's going to change. It's going to grow. It's going to evolve. The employee is going to change and evolve and build new skills. So when you're planning that labor certification, you're really just trying to get as close as you can to what you think the job is going to be. So I tell my clients, hey, if this guy still works for you 5 or 10 years down the road, what do you think he's going to be doing? And if they're like, oh, well, we don't know if he's going to get promoted by then. It's like, well, if he doesn't, if he stagnates, is he actually still going to be working here in the period we're talking about? And then remember too, if you do a labor certification for somebody, and then you do an I-140 petition for somebody, you do a labor certification, doesn't obligate you to the I-140 petition. You do the I-140 petition, it doesn't obligate you to support their adjustment of status, which as the employer, you've got to do the I-485 supplement J, where you're just telling USCIS again, yes, we're still offering this guy the labor certification job. If you don't like him anymore and you don't want to offer him the job anymore, you don't have to. You can't be forced to. So if it's not as big of a deal if you thought that he would be ready, he would be by then the director of analysis, but actually he's not. You actually had to demote him, but you still kept him online. Like, I've never really actually seen that happen with how attenuated the timeframes are, that it's finally the foreign worker's turn to file the adjustment, and the employer who still employs them is like, yeah, now I don't think he's ready for it yet. It's usually been way longer than anybody wanted to wait before we're to that stage. And honestly, it's a more common problem. It's like, well, not only is he was the director of analysis and he got promoted again, and now he's like in an executive role, in which case you may have to do a labor certification again because it's not the same job anymore. It's evolved too far. These are all things that are important to hash through with your attorney. And really, it's worth hashing through before you even promote your H-1B worker, if the H-1B worker has always been with the same organization, because it's really beneficial when you can coordinate the career progression in the H-1B with the labor certification strategy. And in this era, with how slow everything is going, it's just really good to give yourself as much time as possible to get all the way up to that I-140 petition approval. The goal is that before your employee exhausts their 6 years in H-1B status, which includes if they work somewhere else in H-1B status before you even hired them, you want them to have an I-140 approval before they exhaust their H-1B, because if their priority date's not current yet, then they can keep getting 3-year H-1B extensions. If you start your labor certification too late, then there's one other milestone they can hit. If their labor certification's been pending for a year before they run out of 6 years, you can get them 1-year extensions. If that's not even done and the time is too tight for even that, then they will lapse their work authorization. And the only options there are going to be that you terminate them. It could be a suspension, it could be a leave, but they can't work. Or they can exit the United States, work for your organization from abroad in any other country where they're allowed to do so. That could have like tax and payroll and all kinds of complex things you need to worry about. But from an immigration perspective, it's absolutely fine. And then you also could see if they can work in any other status. Maybe they're married to an H-1B worker who has an I-140, and that would enable your employee to change their status from H-1B to H-4 and then get a work permit. It's hard to do that. It's hard to line all that up and not have a lapse. So really, the best thing you can do to protect the continuity of your employee's ability to work is do what you can to support them getting an I-140 petition. If it's through labor certification, then budget 5 months for the prevailing wage, 3 months for recruitment, quiet period, and finishing up and filing. And it's about 450 days, I think. It's about 17 months to get a labor certification approved. Then give yourself a few weeks, get that I-140 petition approved. And hopefully you've done it early enough you don't even need premium processing to get an answer before you hit that 6 years of H-1B. If you get all that done before you hit 6 years, then you can just roll into that next 3-year H-1B period and move on, go on your jolly way. Good luck.